Okay. 9 a.m. Let's continue with our short lectures and lots of labs. This chapter is all about documenting the evidence. In order to obtain evidence from a service provider, a preservation order is requested. There is a section in the law, Title 18 USC, that specifies, in general, a provider of wire or electronic communication services or a remote computing service, upon the request of a governmental entity, shall take all necessary steps to preserve records and other evidence in its possession pending the issuance of a court order or other process. It also has a period of retention. The records are normally retained for 90 days, which shall be extended for additional 90 days upon the renewed request by the governmental entity. Service providers can contact the suspect to let them know they're being investigated. But investigators are more likely to ask judges to request that that information not be known to the suspect in the subpoena. According to the Department of Justice, an investigator should secure the crime scene, ensure the safety of those around, and protect potential evidence from tiny micro SD cards hidden in an area to volatile memory in PCs to remote white functions on cell phones, hidden devices in walls, ceilings, attics in order to maintain a battery life on those evidences. An examiner should always photograph and document everything found at the crime scene, such as the connection of between devices like USB or Ethernet. Document both the digital related and conventional devices, such as the cables, the adapters, the boxes from articles and manuals. Any post-it notes that may have passwords, any USB drives hiding in like jewelry or masked as a toy. This here is a picture of an evidence list sheet to keep track of every little thing. Finding incriminating evidence on a device is worthless if standard operating procedures are not followed. These protocols must be followed from the crime scene to the forensics lab to the courtroom. Defense counsel often spends much of its time questioning the actions taken by investigators instead of focusing on the actual evidence. Just a really big FYI. In the lecture notes, I provided a number of links to like the Department of Justice, the Massachusetts Digital Evidence Courtroom, the Secret Service, Association of Chief Police Officers, and Homeland Security. In regards to the crime scene examinations, investigators should take copious notes about any equipment found, photographing everything, including screenshots. All media devices should be tagged and recorded. Field kits should provide you with all the equipment necessary to get all the evidence. And everything should be properly documented and secured. The assumption must always be that evidence acquired will end up in court. Therefore, everything must be handled in accordance with the law, legally obtained through a court order, a subpoena, a search warrant, or with consent from the owner. As mentioned before, the defense attorneys will examine the chain of custody form and try to find mistakes to render the evidence inadmissible. For example, when making 2 copies of a suspect's drive, there are now multiple hard drives that must be accounted for on the chain of custody form. Every investigator's computer worksheet should have as much details about the system as possible, such as the suspect and/or custodian, the case number, the date, location, investigator, make, model, serial number, the CPU type, the RAM, the BIOS version, the BIOS sequence, the boot sequence, the OS, any number of drives, the system time and date, the actual time and date versus the one that the computer reported, the number of ports and the types of ports, so on and so forth. And as I said, everything should be photographed and added into the report. For hard drives, specifically, they should be analyzed on their own worksheet, getting everything from the suspect or the custodian, the case number, the make, model, serial number, the drive type, its capacity. This form should also have notes detailing the forensic acquisition, whether it was imaging or cloning process, and the hardware or software used. Details of the destination drive should also be listed. Like, when did the acquisition begin? When did it end? Was the acquisition verified? Was the drive sanitized before starting? Its make, model, serial number, and all that information. Don't forget to add any notes about error messages that the hardware or software displayed, and whether the process needed to be restarted. Likewise, a server should have its own worksheet. So from the basic things of the suspect, custodian, the case number, the date, location, you want to get things like the make, the model, the serial number, the BIOS, the drives, its time and date, the shutdown method, the server type. Was it a file server, an email, web, DNS? What protocols it's using, any drives that were mapped, any domain IP addresses, DNS entries, gateways, passwords, what's logging on and what types of logs exist. In other words, you want to be as thorough as humanly possible when seizing evidence. You want to leave absolutely no stone unturned and document just every little detail, because that's what the defense attorneys will poke at if your report and your notes are not complete. There's a number of tools that you can use to help you in writing your reports. And by the way, these can play into the later cases that you'll be doing, including your final. And those are all in the lecture notes under 6.2 at the very top. Investigators must note the current time and source of the current time. All examined system times must be noted and compared to the investigator's time. It is easiest for the investigator to use UTC. That way you avoid issues with daylight savings time and have all your system clocks synced to UTC. UTC doesn't change. It is definitely one of those formats that is the same no matter where you are on planet Earth. So if you're in a big company and you're doing investigations across the world, syncing to UTC would be the best. And UTC 0 to be exact. So speaking of the report, since that's really the main focus of this chapter, the report should be technically precise, yet it also needs to be comprehensive so that someone with limited technical knowledge can understand the investigator's actions and the report findings. If the report has acronyms or technical terms, they should all be explained. There should be no ambiguity. Using graphical representation for data can help remove some of that ambiguity, like a graphical timeline of events, a graphic of networked friends on a Facebook network, maps indicating geotag with metadata information. Ultimately, your report should be detailed enough for someone to use your report to recreate the same analysis and retrieve the same results. A prudent investigation that produces facts for the case will have nothing to worry about. It is the duty of the investigator to be fair to both the prosecution and to the defense. Your report has to have a number of items. Again, we're covering it now. This is going to come into effect when you start making reports for your cases, and absolutely required when you do your finals. So all this covering now, make a note because you'll be coming back to this later. These are all the things that will be expected in your reports. There should be a cover page with your report title, the author or authors, department organization, investigation number, report date, signature, and dates of all involved in the investigation. There should be a table of contents in order to assist attorneys and any expert witnesses. There should be an executive summary, the synopsis of the purpose of the investigation and the investigator's major findings. Any work done by more than law enforcement agencies should be included and clearly outlined in the report. There should be a biography section, a brief biography of the investigator, highlighting all relevant experience, such as college degrees, certification, digital forensics training classes completed, hours of training hours, detailed investigative and professional experience. This section should explain why the investigator was a suitable expert to conduct investigation and produce reliable findings related to the case. An optional part in your report would be the purpose of the investigation. A report writer may have explained the reason for conducting the investigation in the executive summary. Investigators may use this to explain the reason for the investigation and the scope of the warrant. Next comes the methodology. Explains the science behind the examination, the approach the examiner took with the rationale for the choice of hardware and software used. Investigators can reference standard practices used from the DOJ or NIST, for example. It should be the electronic media analyzed. Detailed description of the media examined, how the storage media related to other media examined, objects related to the suspect, all dates and times detailed and clearly outlined for every step taken in the investigation. The report findings. It's important for the investigator to state the facts and be careful about interpretations, which is for the attorneys and the jury to decide. For example, this is a improper report findings. John Doe downloaded thousands of images of children being abused. That is improper. Proper would be an analysis was performed on the hard disk, removed from a Dell computer model this, with a service tag this. This computer was seized from the residence of John Doe and have the address. A total of 578,239 images of children were downloaded to this computer. John Doe noted in his statement to police, dated a date, that he was the only user of that computer at the residence. During the analysis, it was discovered from an analysis of Windows registry that only one user was set up on the computer. The examiner also discovered login and password on this Dell computer. You see the difference? With the improper, it just went directly into interpretation. The proper did not. It stated facts and facts alone. There should be a section for investigation details connected to the case. Any notes supporting evidence to the investigation that is not digital, like statements from suspects and witnesses. There should be an exhibits and appendices. The photos of seized objects, screenshots of the computer screen, tagged photos, printed emails, and other files of interest. Appendices can include forms like the evidence list and the search warrant. And then at the very end is the glossary. Placing a comprehensive glossary is a good practice, as it will diminish any arguments of inequality. Because again, defense counsels often argue that they were at disadvantage because of the lack of resources available to their investigation compared to those to law enforcement. And now for the section that is related to this week's lab. The expert witness. An expert witness can create an investigative report or review the findings of a report and interpret those findings based on specialized education, training, and knowledge. They are usually hired by the defense or the prosecuting attorney to be an advisor and can be called upon during a trial to discredit or refute the report findings, draw out the importance of incriminating evidence highlighted in the report. In a trial, expert witnesses educate the jury. Any expert witness called to testify will most certainly be cross-examined. The role of the expert witness at trial is described in the Federal Rules of Evidence, or FRE 704. The goals of the expert witness, as stated, is to educate the jury and break down complex concepts into meaningful information, such as using metaphors or other analogies to aid with comprehension. The expert is also there to persuade while weaving in important concepts that can help. The expert should aim to imprint core concepts into the minds of the jurors through repetition of these concepts. In most cases, expert witnesses are required to provide a written report. And that can have everything from the complete statement of all opinions, the facts, any exhibits that will be used to summarize or support those facts, witness qualifications, a list of other cases where the witness testified, and a statement of compensation to be paid for the study and testimony in a case. An expert witness should ensure that they are up to date and have refreshed their memory about the document in question, being the report. If you will be acting as an expert witness, the client's attorney will help you prepare for your expert testimony. An expert witness may bring a portfolio of exhibits and prompts to court to help explain concepts clear with the attorney beforehand. It's perfectly acceptable to bring a binder of well-organized notes to the trial and refer to when questions are asked. And here are a few other notes. An expert witness can be asked hypothetical questions. When answering these types of questions, the answer must be rooted in facts. An expert should resist going beyond answering the question and not volunteer additional information. The expert should resist being pulled out of his or her realm of experience, which could totally be a ploy by the defense to discredit their expertise and make them look uncomfortable and less confident. Again, the whole job of the defense is just to put doubt. If the defense can put doubt into the jury, that's it, game over. The expert should always be courteous to everyone in the court, especially with the court reporter and judge. Never talk over someone else speaking in the courtroom, or the court reporter will have to reprimand you. Always addressing the judge as your honor, not miss or ma'am. When answering questions, be clear about who did what and when. Always avoid qualifying words such as probably. Have the conviction to say, I don't know, that is outside my area of expertise. When summarizing key concepts, be sure to include important facts derived from the evidence. And as always, be clear about any units of measurement. For example, 8 gigabytes of RAM. Also pay particular attention to the time zones, which defense attorneys will question. And speaking of questions, any questions? Okay. Well, seeing no questions in the chat, here is what is on the to-do list for this week. You will watch 3 different digital forensics experts in trial. I have given you a link to one. You could totally start with this one and then find 2 others on YouTube, or pick 3 as you wish. Watch them do their thing and then make a report. Again, it doesn't have to be a 5-page essay for every single video you watch. That's not what I'm looking for. Things that I do want you to answer in your findings are, what are things that they all did that you should replicate? What are things that maybe they did that you should not do? Any tips that you picked up and any tricks that you saw done in their when they were on trial, when they were sitting in the booth and talking to the defense and to the prosecutors. This would be a nice eye-opening experience into how digital forensic experts have to work in the courtroom. Especially for those of you who want to get into this field, you need to be well aware of these kinds of things, because you will more than likely end up in the hot seat. This week is also case number 2. And here you have the scenario. You have the link to the case files. I provided all the MD5 sums for the files you need, and also gave you the answers, the questions that you need to answer. There's 31 of them. So before you take this quiz, answer all 31, have all that ready to go, and then enter the quiz and just copy paste your answers, your findings. And as I said last week, I encourage you to work together. I encourage you to use Discord, our text channel, to communicate with each other and work together on these cases. 31 questions may seem daunting for a single person, but not so much when you're working with others. And that is totally fine for this class. You are not cheating. You are not, you're not going to get penalized for working together. I see a question in the chat. How many videos? 3. You're watching 3 different digital forensic expert witnesses videos. Other questions on this assignment or this case? I see no questions.